I'd like to thank UQuam for inviting me to present here today. And I'd like to acknowledge the really transformative effect that the conference organized by UQuam and Manon and her team in 2018 had, I think, on discussions about sexual violence policies and complaints across the country. For me at that time, I was just starting to work in this area, and the conference provided me with the opportunity to meet with people that were doing this work. And I think it's fair to say that if that conference had not been held, I would not be doing this work today. I would not have written the book. It was really transformative and really a fabulous opportunity for people to meet together. So I just want to acknowledge the important work of that conference in 2018. Sometimes we forget now that we're not meeting people as regularly, that you know, we are missing things during this COVID time. So just, I remember that conference as being truly fantastic. So what I'm going to do today is describe 13 barriers or hurdles to obtaining justice under formal post-secondary institution complaint processes. So what are some of the barriers? And after I describe the barrier, what I'm going to do is anticipate what kinds of cases might go to court about the barriers. So where can we anticipate a judicial review application in the not too distant future? So I want to look at where complaints are vulnerable to a court challenge. I want to stress that I would really like to have lots of time for discussion, and if there's something you don't understand, let me know, you know, in the chat. I'll watch the chat as we go along. And as I said to Marie Soleil before we started, I speak very quickly sometimes. Yeah. So if I'm speaking too quickly, please don't hesitate to ask me to slow down. Okay, so what are some of the barriers to justice? I want to mention our book. So following the conference, I realized I learned so many of the things that people don't have a basic understanding around administrative law. I teach administrative law. I've taught administrative law for 30 years. So I thought I'm in a position to explain many of the concepts related to procedural law that that even lawyers don't understand that well, and non-lawyers really don't understand. So I realized there was a need for a relatively straightforward, simple explanation of administrative law. And I would note that the principles of administrative law in Quebec and in the rest of Canada are the same. It's the same base law. It's not like the civil and common law system for contracts and other things. The law on administrative law is the same. But the book brought together three of my interests. It brought together my interest in working at a university. I understood universities, so I thought, unlike most lawyers, I was in a position to explain how universities operate. Two, it brought together my expertise in teaching administrative law. And thirdly, my main research area as an academic over the last 30 years has been on gender-based violence. So it brought together my interest on gender-based violence. So I asked Joanna Birenbaum, who's a well-known lawyer in Toronto. She works with a lot of sexual violence complainants, and Joanna and I've worked on cases before, if she would co-write the book with me, because I wanted to make sure that the book was very practical, that it wasn't academic, it wasn't too theoretical, but it was really straightforward, practical, and grounded in reality. And Joanna was a fantastic co-author. I couldn't have asked for a better co-author. Now, one of the things that we do in the book, one of our methodologies, is we compare the policies on formal complaint processes at 25 post-secondary institutions across the country. Now, our sampling, there was some method to our sampling, and we had 3 Quebec universities in the sample: Université de Montréal, McGill, and a cégep. So we wanted to include a cégep because, of course, that's unique to Quebec in our sample. So when I talk today about most policies or some policies or only a few policies, what I'm doing is talking about the 25 policies that we reviewed for our book. That's the data set that I'm talking about. And you can see that what we looked at in our book, sort of by themes, we looked at some issues related to procedural fairness. The book starts out by looking at procedural fairness. The book also tries to explain basic rules of evidence law. Then it goes on to describe things like the substantive law relating to what is sexual violence. And then there's a whole chapter on that looks at the consumption of alcohol, because that's a huge issue in these cases. And then we look at sanctions. And so what are some, if someone is found to have violated a policy, what should happen to them? And we also look at privacy issues, because they're very complicated in these cases. So this is a range of things that we talk about in the book, and I'm happy to answer questions on aspects of the book if that's of interest to you. Okay, so what are some of the barriers to getting justice under the policies? Well, the first barrier is kind of a surprising one. It's that justice for survivors is not actually the policy objective for formal complaints. So getting justice for survivors is not what's intended to happen coming out of formal complaints. There are processes that are intended to get justice for complainants, such as civil actions, filing a case in a civil court, or filing a human rights complaint. But like criminal cases, a formal complaint under a university policy, at least under most university policies, survivors are bystanders, are witnesses, are onlookers. What they want to have happen is not really a consideration. So another way of saying this is that the objectives of these policies are not survivor-centered. Rather, the objectives are, first of all, to create a work, learning, and living environment free from discrimination and harassment for all people in the environment. And secondly, to hold the respondent to some type of accountability. So those are the objectives. They're to create a certain environment at the institution and to hold the respondent accountable. Now, our understanding of this helps us to realize why under many policies, survivors' participatory rights, so their ability to participate and guide or have a major role in investigation processes or hearing processes, is limited. And as well, their right to information about what's going on during the process can also be limited. So that's a huge barrier, is what is the objective of these policies. The second barrier I just want to briefly mention is that civil actions, so court actions against complainants and supporters or allies for even raising an allegation of sexual violence, are becoming more common. You might be familiar with the case in at University of British Columbia involving a complaint made against a professor. And ultimately the professor's position was terminated at the university. And he has now sued the complainant, and he sued all of her allies. He sued people that made social media tweets that were supportive of her in one way or another. And he's alleging breach of privacy and alleging defamation. So that's one example. The Galloway case, Stephen Galloway has sued the complainant and many others. Now, I'm not saying he's going to be successful, but the fact of a civil suit is very intimidating to those who get sued. There's also a situation in Ontario where a law professor helped a couple of students formulate a complaint. And when the professor left the university, he got a job at another institution out of the country. And she contacted that institution saying, did you know he was released under suspicious circumstances? And she was sued, and he was successful in his lawsuit and got a damages award against her. So those are just two examples. There are others, but two examples of a civil suit against a survivor. And in both cases, there were serious consequences for the respondent from the institutional level, and yet that didn't stop the civil process from going ahead. So I think one of the things that we can do is we can anticipate more lawsuits in defamation lawsuits in breach of privacy, and lawsuits for wrongful termination of employment. So I think this is a huge barrier for complainants and their supporters and allies, is the fear of being sued. The next barrier that I want to mention is that some of the policies are very narrow in what they cover. So some are broad, but some are narrow. So some policies only cover conduct rather, that where the event actually occurred on campus, or where the event has a direct connection to an institutional activity. So for example, if it occurred on a field trip or something like that. Now, if it has to occur on campus, or if it has to have a direct connection to an institutional activity, very few cases will meet this criteria. Most sexual violence between students, and I would think also between students and faculty or other staff, occur in someone's home. And when it under, I would say probably more than half the policies, if it occurs in someone's home, it's not captured by the policy. Now, some policies, about half the policies we looked at, are broad. They cover any conduct between students and our faculty and staff that could have an impact on the work, learning, or living environment. So if that's the test, is does it have an impact, a negative impact on the work, learning, or living environment? And if it does could have that negative impact, then that's sufficient to trigger a complaint. So there's a real difference between the policies on this point. Now, what's something that we can anticipate? I think we can anticipate a judicial review application. So that's an application to court challenging the reach or scope of a broad policy. So someone who thinks that the policy should not be able to apply to conduct in someone's home that doesn't have didn't occur on campus or in connection with a university event, that the policies can't be that broad. I think those applications will fail. I think that the legislation is broad enough to allow for policies to capture off-campus events, but it's possible that that won't happen. We'll have to wait and see, what happens with those cases. A related issue is whether or not an institution can continue to investigate a complaint even where a respondent leaves the institution after the complaint is filed. So what happens, for example, if a complaint is filed against a student and the student drops out or withdraws from his courses? Can the institution continue to investigate even in those circumstances? I would say at the institutions that I know of that have faced this problem, about half of the institutions have continued the investigation. And again, about half the institutions have not continued the investigation when the student has left. So that one is still up in the air. Okay, a fourth, there we go. A fourth barrier is what I call reciprocal complaints. So what we're seeing, especially in the United States, is the emergence of reciprocal complaints. And what are these? We're seeing that parties with potential complaints racing against each other to give their story to the authorities at their institution before the other does. So let's say two students both had consumed some alcohol, something happened, and the male student races to the office to make a complaint before the female student can make a complaint. So we're seeing dual complaints in increasing numbers in the United States, and that's really of concern. So I just want to mention that to you. A fifth barrier is, in my view, this is a barrier, but feminists have long disagreed on this question. So I just put it out there as a barrier, recognizing that there is disagreement on this point. Many policies have no provisions, or they have weak provisions for alternative processes, such as a restorative justice process. And some policies are silent on this point. Now, assuming that we had trained personnel to do restorative justice processes, and that's a big assumption that we would have that trained personnel, I think we should engage more seriously in a discussion on whether or not we should focus more on alternative processes such as restorative justice. So I just put that on the table, and I would be interested in your thoughts on the utility of restorative justice processes. Now, here's a potential problem that I just want to mention to you, and that is that if there are reports created or if information is collected by the university during an investigation, and it could be information collected by a mediator, even if the mediator isn't associated with the university. But if they collect information about what happened, and then if there is a criminal case, there is a good possibility that the Crown attorney, so the prosecutor in the case, can require production of the record that was created during the alternative process. So let me put this another way. If there's a file on a mediation or a restorative process, then that file can be obtained by the Crown during a criminal investigation. And it is for this reason that many respondents will refuse to participate in an alternative process, because they're afraid that if they make an admission during an alternative process, if they acknowledge that they've created some kind of harm, then that acknowledgement can be used against them in the criminal case. So this is a big problem with alternative processes. It's also a problem with investigations, where respondents don't want to participate in investigations because if they do, what they say during the investigation can be used against them in the criminal proceeding. We can talk more about that if you want to. A sixth barrier to these policies, the success of these policies, is that we don't have enough trained investigators. One of the things that's really important in the investigation of sexual violence complaints is that they be survivor-centered and that they be trauma-informed. And being trauma-informed is particularly important. We need to have investigators that understand that there is no typical reaction to sexual violence, that different complainants will respond in different ways. And that's just one example of being trauma-informed. And we just don't have enough, especially outside of major cities. We just don't have a lot of trained investigators. So this can be a real problem. It'll be interesting to see if one of the things that comes out of COVID is a willingness to do more investigations via Zoom or telephone. So you don't have to find someone who can do the interviews. So that will be interesting to see if that process changes in any kind of material way post-COVID. Now, I just want to mention some things that we might expect an application to court on in relation to investigations. And this would be things like, can an investigator take into account the neurobiology of trauma without speaking to an expert and getting expert advice on the neurobiology of trauma in a particular case? Could an investigator talk about the effects of date rape drugs in an investigation? So, you know, typically if this was a court matter, you would need an expert on neurobiology of trauma, or you would need an expert on date rape drugs. And it's not clear whether or not an investigator can rely on their own expertise in these matters when writing an investigation report. The other thing that we can expect an application to court on is a respondent alleging what's called a reasonable apprehension of bias in English. And in particular, there are two ways in which I think we can anticipate a reasonable apprehension of bias complaint. One is a complaint based on the idea that investigators are biased because they're known feminists, they're known to be active in the anti-violence world, and that because they're known to be feminists or known to be active in the anti-violence world, they would inherently be biased in favor of a complainant. So this is one kind of application. I won't be surprised if we see that. Now, in my view, those applications should not succeed unless the investigator has done something in the specific case to indicate that his or her mind is closed to the possibility that no breach violation occurred. But nonetheless, I think we will see an application alleging reasonable apprehension of bias on the part of an investigator. Another barrier is that about half of the policies don't make it clear that complainants have participatory rights during investigations, and fewer give complainants participatory rights on internal reviews. So what is the practical effect of treating a complainant as a party without procedural rights? Well, there are a couple of them. A complainant under almost all policies does not have the capacity to launch an internal review. So if she thinks there's something unfair about the investigation process, she can't do anything about it. She cannot ask an administrator to review or a special panel to review in the same way as respondents might be able to get that kind of review. And secondly, if she's not a party, then her right to access to information might be constrained. And in about a quarter of the policies, she does not even have the right to know what the outcome of the investigation is. So did the investigator find that the policy was breached or not breached? Under about a quarter of the policies, she doesn't have the right to that information. And to me, that's really shocking. She doesn't even have the satisfaction of knowing what the outcome is. So that, I think, is a huge barrier to justice under these policies if you can't even know what the outcome is. Now, I would just mention one area here where we can expect, I think, an application for judicial review. And this is on a slightly different point than participants' rights. It has to do with respondents' rights. Many policies are unclear or have highly restrictive provisions on the right to counsel for respondents. Some outright say that respondents cannot be represented by lawyers. Some say lawyers can come to meetings but can't say anything. Others restrict the ability of lawyers to represent respondents in a variety of ways. And again, I think given the nature of the rights at stake, that we can, sorry, I went ahead too soon. I think we can foresee an application for judicial review seeking to have those provisions set aside, the ones that restrict the assistance of counsel. Another barrier to justice is the insidious influence of criminal law norms. Now, criminal law rules should not apply in campus sexual violence complaints. They don't have a role to play in campus sexual violence complaints. But there can be a tendency to slip back into criminal law rules. Let me give you two concrete examples of that. Some policies specifically say that if a complainant is intoxicated, she cannot give consent. That's not the criminal law rule. An intoxicated complainant can give consent. Only someone who's either unconscious or someone who does not appreciate the nature of the act they're engaged in can't give consent. So it has to be intoxication to the point of incapacity, or intoxication to the point of not being aware of what's going on around her that's required in order to get a criminal conviction. Under a campus sexual violence policy, the level of consciousness is often much lower. So if she's intoxicated, she cannot give consent is the rule in some policies. In some policies, there has to be affirmative consent, verbal affirmative consent. So she has to verbally have said yes to engage in the sexual behavior. And if there isn't a verbal consent, then the policy has been breached. And here again, the criminal law does not require a verbal consent. It requires an activity indicating consent, but it doesn't specify that it must be verbal. So the criminal standard is more rigid than the standard under the policies. Some policies also have a blanket prohibition on the use of any sexual history evidence. So they just say you can't use it. You cannot use it at all. And what we see, what I think we can anticipate seeing is if respondents are denied the ability to question complainants about their sexual history, that we will see applications to court arguing that that information should be able to be information that can be sought by a respondent. Okay, so where do I think we might see judicial review applications? I think we might see judicial review applications on what constitutes sexual violence under acts. We might see judicial review applications on use of sexual history evidence. And in particular, we might see judicial review applications on disruptions to the defendant's right to silence. So those are all areas where I think these policies are ripe for a judicial review application. I mentioned a minute ago the concept of reasonable apprehension of bias, and I want to mention one particular problem with reasonable apprehension of bias, and that is that policies often have the principle of believe the complainant built into the policy, or the institution has a policy of believe the complainant. And at some institutions, they had believe the complainant campaigns. So they created videos and other resources that exhorted institutional actors to believe the complainant. And I think that these believe the complainant campaigns, which I totally understand the reason why those campaigns would be in place, but the fact of the campaign can give rise to a claim that the institution is biased in favor of the complainant, that they have closed their mind to the possibility that the respondent is the one telling the truth. And in consequence of the fear of that allegation being made, most institutions have now eliminated reference to believe the complainant in their formal policies, and instead now say that complainants will be treated with respect and dignity. Or they'll say that both the respondent and the complainant will be treated with respect and dignity. So we've seen, I think, the end of believe the complainant campaigns because of the possibility that they give rise to an institutional bias against respondents. The 10th barrier I want to mention is the prospect of a hearing before a student disciplinary panel. Now, when post-secondary institutions across Canada started implementing sexual violence policies, it's within the last decade, they did a pretty good job of ensuring that those policies were survivor-centric and trauma-informed. This meant, for example, that respondents and complainants would never have to meet face-to-face, and also that the process should move ahead quickly, that it shouldn't be delayed. Now, all of this good work goes out the window when policies provide that following an investigation and following a determination by an administrator as to whether or not there's been a breach of a policy and some sanction approved, when the policy then provides that there's an ability to have a full, fresh oral hearing before a student discipline panel. All of the work of the sexual violence policy is wiped out if a respondent has the ability to have the whole matter start over and be heard anew, fresh, clean, by a student disciplinary panel. Not only does this mean face-to-face hearings, and even the prospect that the respondent himself does the cross-examination of the plaintiff, it also means that the hearing might not occur for months. So there will be significant delay. And the reason, of course, for the delay is because you have to find a time when all of the people can come together at the same time for a hearing. And that can sometimes take months. The other thing that happens when you have the possibility of a student discipline panel is that it permits the respondent to refuse to participate in the investigation because he knows the investigation doesn't matter. If he's found to have breached the policy at the investigation stage, he's not hurt by it because he has the right to have the matter go to a full oral hearing, no matter what the investigator found. Now, student discipline panels are completely ill-suited to the hearing of sexual violence complaints. I'll give you one startling example. At University of Alberta, a student discipline committee is made up of 2 students and a professor. And it could be a professor in chemistry, and it could be an architectural student and a student from the Faculty of Environmental Science. So students don't know anything at all about sexual violence, but the final matter could be heard by them. So they have no knowledge of the policies, no knowledge of sexual violence laws, and no knowledge of the historic treatment of complainants and so on. So the fact that student disciplinary panels were the final step under many of these policies was deeply problematic. Now, I'm happy to say that the trend has been to move away from in-person adversarial disciplinary hearings. And so by June 2020, of the 25 policies that we reviewed, only 7 still allowed for hearings before a student disciplinary panel. That's still 1 out of 3. So that's still very high that allowed for these. But all other PSIs surveyed now leave final fact finding as to whether or not sexual violence occurred to either the investigator or a senior administrator or a specially constituted panel. Now, student disciplinary panels might have a role to play in sanction and remedies, but they don't have a role to play at most institutions now on the question of whether or not the policy was breached. So we'll see whether or not we'll have this trend continued. But, you know, at institutions where, including my institution currently, where there is a possibility of a student disciplinary hearing, we don't see any complaints because we know that the complaints are futile when the final step is a fresh hearing before a student disciplinary panel. Now, what can we see in the future? We can anticipate an application to court on the fairness of limiting the right to an in-person hearing and limiting the respondent's right to cross-examine. Because of course, if you don't have an in-person hearing, you do not have the right to cross-examine. The right to cross-examine can only be exercised at an in-person hearing. Okay, we're getting close to the end here. Number 11, what is number 11? Number 11 is the narrow interpretation of privacy laws. Now, I alluded to this a little while ago. Some institutions refuse to share with complainants even redacted versions of investigators' reports, summary of findings made, or allegations or information relating to sanctions or remedial action. So complainants have no right to know anything about what happened in the case. And I just want to mention briefly something that happened in a recent University of Manitoba case. There was a very high profile case where there was a complaint made against a professor. We don't know how many students were involved. It could be 3, it could be 20, we don't know, but there were multiple complaints made. The media was very interested in the case. The professor left the institution after the investigation report was finalized, but the investigation report wasn't made public, and complainants got to see what was said about their specific complaint in the investigator's report, but not more. And and we don't know the circumstances under which, like, did he agree to leave or what happened? We don't know, but the professor grieved his whatever happened to him, and we have an arbitrator's report that says that orders him to the university to pay him $250,000. But under reading the arbitrator's report, you don't know why he got awarded. It's $286,000. You don't know why he was awarded that. The arbitrator is silent on why he was awarded $286,000. The arbitrator also says that he was prepared to reinstate the faculty member to his position, but the griever declined reinstatement. But he doesn't say why he would reinstate. And he also says that everything has to be kept strictly confidential, and if the parties want to talk about the case at all, they first have to get permission from the arbitrator to talk about the case. So University of Manitoba can't, like a researcher like me or a lawyer can't understand what norms are created by this decision. So what is it that University of Manitoba did wrong in the course of the investigation or in its handling of media? We don't know. And yeah, we have this silly decision which has conclusions in it, but as an example of a case of what is good practice and what is good and what is not good practice, we simply don't get information because of privacy restrictions. Now, related to that, I want to I want to mention my 12th concern about these policies, and that is that we don't have aggregate data on anything under these policies. So we don't have aggregate data on things like what kinds of interim measures are taken, what kind of disciplinary measures and remedial sanctions are taken. We don't have information on what are typical mitigating or aggravating circumstances. So, you know, like we don't know what a typical outcome is in these cases. Is it usual for a respondent to be given a 2-year suspension or a permanent withdrawal, or just being told to take some kind of remedial course? We don't know. We don't know what the outcomes are in these cases. There isn't any aggregate information either on an institutional level or on a broader level about what happens in these cases. So at my own institution, again, I can't tell you how many complaints are made, and I can't tell you how many complaints are investigated, and I can't tell you how many complaints go to disciplinary panels. My sense is almost none do, but there is no formal information out there on what's happening under the policies. And then the final barrier to justice that I would mention, so the 13, the baker's dozen is what we would say in English, is lack of institutional public accountability. And here the problem I want to mention is that most provincial legislatures don't require institutions to prepare annual reports that must be made public. So again, as I just mentioned, we don't have any idea about how many complaints were made against professors and students. We don't know how many informal disclosures there are. We have no idea of what the outcomes are. Our respondents sometimes, always, never found to have breached policies. And it's very hard to evaluate the effectiveness of sexual violence policies in the absence of any data. So those are my 13 barriers to justice under these policies, and I'm happy to take questions now.